Good afternoon, and I'm really pleased with the number of you who have chosen to stay here. I know that this was going to be part of the networking, but I do believe that we are going to engage in some quite interesting, current, and critical discussion. As the moderator, I'm going to moderate very little. We have an hour, and I know there's a lot of questions. All of you in your packets have the bios of our excellent panel, and I'm not going to dwell on it at all. I'm going to introduce the names of the individuals and then move forward. Suffice to say that we're extraordinarily fortunate to have some of the critical folks involved in this debate and discussion, and that is the Arizona law that was passed dealing with the issue of the undocumented and most importantly from our perspective, the constitutional issues that it raised. We're going to go and try to give you a sort of set the stage. The first speaker will be Mary Rose Wilcox. I have known Mary Rose for 35 years. She is an institution in Arizona, in Phoenix, in Maricopa County, and has been involved in civil rights and human rights her entire life. We then have Professor Chin, one of the most quoted professors in the United States, and someone who has written one of the best articles to date on the implication of the law in Arizona. And then we have Tom Saenz, the President and General Counsel of the Mexican American Legal Defense Fund, the individual who, while I was in Maldives, litigated Prop 187 with the ACLU in California, and one of the best litigators in the country. And with that, we will start with Mary Rose to give you sort of the social human context of what's happening in Arizona and the impact that it's having in the Arizona community. Mary Rose.
Thank you, Antonia, and it's a real honor for me to be here. I'm going to buy you all tickets to come to Arizona and change our climate, okay? Because we need you. It is hell in Arizona right now. I've been elected official for almost 24 years, and we've always been a very independent state. We've been the state where our Governor Ed Meekum, many, many years ago, canceled the Martin Luther King holiday, and we had to take it to the voter to get it. We've been an independent state, but the hate that is going on in Arizona is tremendous. I'm going to give you a little bit of the history as I see it, how we got here. We have always had propositions that were immigrant bashing in Arizona, but in 2004, a bill passed that dealt with human smuggling in the state legislature. The bill was good intentioned. The bill's intent was to take care of an issue we had of many people being abused by human smugglers coming in. Many people, a lot of undocumented, had been executed. There had been a series of crimes, and a very conservative lawmaker passed a human smuggling bill. The bill was on the books, and in 2004, Andrew Thomas, who is a Maricopa County attorney, he's since left, but he was the attorney at that time, came into office on the back of immigrant bashing. And when this bill came in and Andrew Thomas started to empower himself on the backs of immigrants, he interpreted the bill 2 years after its passage to say that that bill not only applied to the person who was smuggling, but the people who were being smuggled. And he opened the door for arrests to occur left and right. No other county attorney, we have 15 counties in the state of Arizona, interpreted the bill that way, and they did not prosecute. But Andrew Thomas opened the door for Sheriff Joe Arpaio, who many of you have heard of, to start going out into our community and jumping on the bandwagon to get publicity for himself off of this immigration bill. You've got to understand, Joe Arpaio is a publicity hog. I have served with him for 17 years, and he had always done things like pink underwear, tent cities, always done things, but he had been a friend of the immigrant community. In fact, when the human smuggling bill first passed, it was Joe Arpaio who said we need this because he was the one investigating a whole series of executions in western Maricopa County. When Andrew Thomas came in and started getting the publicity, Joe wanted in. So when the bill was interpreted, Joe decided he was going to take advantage of the 287G program that we had entered into at Maricopa County with ICE, and he decided that he would use this program and this bill and started raids in predominantly Hispanic areas of Maricopa County. The first raid that he did in 2007 basically went into the town of Guadalupe. Guadalupe is a town that is 5,000 people in the middle of our metropolitan area. It is a Yaqui and a Mexican-American community. Joe Arpaio went in. He went in with 50 squad cars. The town is a mile, not even a mile. It's about 3/4 of a mile long. He went in with 50 squad cars and a tank that he put in the city square. And he went in with a show of force that was incredible. And he stopped people left and right. He violated all kinds of people's civil rights, human rights. And people started realizing this man is going to cause havoc in Arizona. And people started to get scared because Joe Arpaio, if you spoke up, started investigating people. The mayor of Guadalupe spoke up. He started an investigation on her. And later she was arrested for not having a tail light. She had a tail light that was broken, and she was arrested. So the pattern started to be set. He started his raids. He started really just terrifying day laborers. Not only would he stop when day laborers were congregated, but he would follow them into neighborhoods, and his deputies would be knocking on the doors of the communities where day laborers lived and asking if they were citizens or not. So even before 1070, Joe Arpaio had started this trend. He also started something that was very abusive. If you questioned the policies that he was putting in place, he would basically start investigating you, and he emboldened the state legislature to say, let's do more immigration laws. We can get the attention Joe Arpaio has gotten, we'll get national attention, and we could stop our illegal immigration issue. The problem is there's not a high crime rate among the undocumented community. Our borders, and you might hear everything else under the sun, but our border cities have low crime rates. Yes, there is an ebb and flow across our borders, and yes, we need immigration reform. Everybody knows we need a jobs bill, an ag bill, and we have always had a traditional ebb and flow across our borders. But they started criminalizing our immigrant communities, and not only our undocumented, but everybody who is a citizen in Arizona. I'm a fourth-generation Mexican-American from Arizona, and I can't tell you the fear that people are having. When Janet Napolitano was governor, she was able to stem the state legislature from introducing bills that were very, very onerous because they knew that she would veto them. A few got through, but she was able to curb it. Once she left, the dike was just, there was no stopping the flow of bills that came through. And we had bills that dealt with federal issues left and right. And at the same time, you had Arpaio emboldening everybody in town to say, if we go against the immigrant community, this is very popular. The right came in, militia came in, the border all of a sudden had people coming to it, said we must protect it. And I'm sorry I'm kind of emotional, but this is really a tragedy in Arizona, and I'm right in the middle of it. Janet Napolitano took $1.5 million away from Joe Arpaio. It was called Funds for Get 'em. It was to get criminals. Joe Arpaio was using it in his immigration raids. She took the money away. Joe Arpaio blamed me because he said that I had gone to Congress and asked him to investigate 287G. He indicted me in December of this year on 44 felony counts. In March of this year, a Superior Court judge in Pima County took all the charges away and said it was the worst case of political vindictiveness they had ever seen. Consequently, 4 other cases were dropped too, including a sitting Superior Court judge who had had the audacity to go against Andrew Thomas and Joe Arpaio in interpreting some of the laws that they wanted. So I just will answer questions later, but I must tell you, if we do not get an injunction against 1070, Arizona will have political unrest as never before. You will see people getting arrested left and right. You will see civil disobedience. You will see the youth in our community who, quite frankly, will no longer take this, rebel. We are very grateful to Tom Sines and Maldeff and all of the people who have joined in that lawsuit. We hope Eric Holder has the compassion and does the right thing and enters and helps us get an injunction. But Arizona is in the middle of a firestorm, and if we do not control it in Arizona, it will happen in a lot of other states. We have people, and I travel quite a bit, who come up and say, aren't you glad you're controlling illegal immigration? We want to do the same thing. I look at them and say, ay, Dios mío. But, you know, I just... But let me conclude by just thanking Tom and Antonia and all of you for inviting me, because the story in Arizona needs to be heard, it needs to be felt, and it needs to be stopped.
Thank you, Mary Rose. Now that you have a sense of what is happening on the ground, Professor Chin will make an effort, and as I said, an expert on this issue, to actually tell us what the legislation is and how it conflicts, whether and how it conflicts with federal law. So with that, I turn it over to you, Professor Chin.
Thank you. So I'm from Arizona, as you know, and so I'm so pleased to see all of you carrying proper ID and people checking it at the door. It's beautiful. So SB 1070 is Arizona's new immigration law, as you all know. I want to talk about the specific things that it does. First, it creates 4 new Arizona crimes based in varying degrees on federal criminal law. And an element of each of these new crimes is that the defendant is undocumented. Second, SB 1070 requires line law enforcement officers who make a stop or detention to investigate the immigration status of the person stopped or detained if there's reasonable suspicion that they're undocumented. Third, every single person arrested in Arizona is going to have their immigration status checked with the federal authorities. Fourth, every undocumented person who's convicted of a state or local offense, such as the Class 3 misdemeanor of walking a dog without a leash, is going to be reported to the federal immigration authorities, obviously to facilitate deportation. Finally, SB 1070 restricts the ability of county supervisors, city councils, and other executive branch or police chiefs to control the conduct of employees. So law enforcement agencies and non-law enforcement agencies cannot prohibit their employees from investigating and reporting the immigration status of the people that they come into contact with. So if a police chief were to impose a policy that said, we generally do not investigate the immigration status of victims or witnesses, that would be a violation of the law and the chief could be sued. Now, SB 1070 is not new in that it involves local Arizona police in federal immigration enforcement. There's a Ninth Circuit decision, there is an Arizona Supreme Court decision, there's a 1996 OLC opinion that says that local police can make arrests for violations of federal criminal immigration laws, not because somebody is deportable civilly, but because they've committed an immigration crime like reentry after deportation. It's also been the case for many years that a police officer could ask any person at any time, any question, consensually. So if there's no stop, no seizure, the police can ask anyone at any time about their immigration status. And there's a 2005 Supreme Court opinion called Mueller versus Mena that makes that point. Local law enforcement officers can ask questions about immigration status. In addition, for a long time, if local Arizona law enforcement officers had reasonable suspicion that somebody they had stopped was undocumented, they would call the Border Patrol or Immigration and Customs Enforcement to give them a chance to pick them up. So none of that is new. What is new is that before SB 1070, the Arizona police had to turn over someone that they had stopped to the federal authorities for them to do whatever they wanted to do. And for the most part, federal authorities did not prosecute strawberry pickers merely because they were undocumented. And so the innovation, the genius of SB 1070 is that it gives Arizona law enforcement officials like Sheriff Joe Arpaio and County Attorney Andrew Thomas the ability to make the decision that these people will actually be prosecuted. And so now the law enforcement system can scoop up people who have committed no crime other than related to their immigration status. Now, President Obama, Representative Sanchez, a number of people have talked about the potential for racial profiling in SB 1070. Conservatives, some deny that SB 1070 has the seeds of racial profiling in it. Other people worry that it does. Ilya Shapiro of the Cato Institute is the only person I know who's gotten this right. And the answer, as I see it, and I'm prepared to defend it, is that SB 1070 explicitly authorizes and maybe requires racial profiling. It says the police cannot consider race, color, or national origin except as permitted by the U.S. or Arizona Constitution. So now we go to the U.S. and Arizona Constitution. The U.S. Supreme Court, in a case called the United States versus Brignoni-Ponce, says the likelihood that any given person of Mexican ancestry is an alien is high enough to make Mexican appearance a relevant factor. The Arizona Supreme Court agrees. Enforcement of immigration laws, it says, often involves a relevant consideration of ethnic factors. And so SB 1070 is the first statute that I'm aware of that explicitly, textually authorizes racial profiling, and it does. The statute also authorizes pretextual stops. SB 1070 adds to the human smuggling statute that was put on the books a few years ago that a peace officer can lawfully stop any person who's operating a motor vehicle if the officer has reasonable suspicion to believe the person is in violation of any civil traffic law. This is a reference to a case called Wren versus United States from 1996, where the Supreme Court held that a police officer with probable cause can make a stop or arrest, and that stop or arrest is per se reasonable based on probable cause, even if the actual motivation for the stop or arrest was to investigate some other crime for which there's no probable cause, or racial bias, racial profiling. In either instance, it's okay, and Justices Breyer, Ginsburg, Souter, and Stevens joined a unanimous decision, a unanimous decision written by Justice Scalia saying that subjective intentions play no role in ordinary probable cause Fourth Amendment analysis. So there's a unanimous decision that stops are not unreasonable under the Fourth Amendment merely because they're based on race. So of course SB 1070 facilitates racial discrimination. Of course SB 1070 is aimed at Mexicans. But don't blame Arizona. Don't blame the Arizona legislature. Blame the U.S. Supreme Court. All SB 1070 does in this regard is take full advantage of the controlling cases. And until those cases are overruled, SB 1070's endorsement, embrace, enthusiasm for racial profiling is not a reason that it might be unconstitutional. I assume that the next speaker is going to talk about why SB 1070 might be unconstitutional, and I assume that it is unconstitutional based on a very persuasive preliminary injunction motion in large part. But even if that's true, even if it is unconstitutional in large part, there's a couple of important points that I want to leave you with. One is the proponents of SB 1070, at least in Arizona, have already won. The point of SB 1070 was not about making cases and putting people in Sheriff Joe Arpaio's tents. It was about sending the message, go away. Arizona is going to continually do whatever it can to make your life as difficult as possible, so go away. And I believe that message has been heard. The newspapers are reporting an exodus in Arizona. The second thing that's important is that I doubt that every single provision of the many provisions in SB 1070 is unconstitutional. In my opinion, SB 1070 was quite self-consciously drafted as a test, as an experiment, with a lot of different methods of imposing suffering here. And some of them are going to be constitutional. And so I think that even a preliminary injunction or a permanent injunction that invalidates a number of different parts of this law is just the first step, because some of the parts aren't going to be invalidated, and those parts are going to be amplified in Arizona, and they're going to be disseminated to other states.
Thank you, Professor. And while the discussion's going on, please feel free to write questions that you would want to pursue the dialogue, and those questions will be given to me. So Tom, now it's up to you to invalidate the law. So how are you going to do it?
Well, that's daunting, but I first want to counter any rumors that they put these tables up here and these plants up here to hide our shoes, so that someone might draw conclusions from them. But there is precedent. Antonia alluded to Proposition 187 in California, which was enacted 16 years ago by voters in California and was immediately restrained in federal court, preliminarily enjoined in federal court, and ultimately 4 years later, after a very lengthy and twisted course, struck down and permanently enjoined with the exception of 2 minor provisions. And struck down by Judge Mariana Felser in the Central District of California, a very careful, wise judge, struck down on the basis that it violates the Supremacy Clause, that it was California's attempt to enact its own immigration regulations, and that under our Constitution, as an outgrowth of the naturalization power and the power to conduct foreign relations, only the federal government has the right and authority to regulate immigration. And California's Proposition 187, by attempting, using remarkably similar words like reasonable suspicion, attempted to basically enlist every public servant in California in immigration enforcement. And the theory that succeeded there is the first major claim in the lawsuit filed by MALDEF together with the ACLU and the National Immigration Law Center against SB 1070. And Jack's alluded to the preliminary injunction motion that was lodged, slightly oversized, so we're waiting to get permission to actually file the full brief, but we have sought a preliminary injunction. We expect a hearing to occur sometime in July, well in advance of the intended July 29th implementation date of SB 1070. And I think applying the preliminary injunction standard, basically weighing irreparable harm and likelihood of success on the merits, we have a very good case in both regards under the preemption claim alone. But there are, of course, other constitutional flaws, even if, as Jack has indicated, there is precedent that might support some of what is created in SB 1070. There are a number of constitutional flaws here. I think what's remarkable is that there is a precedent of Proposition 187, and there was ample argumentation presented to Governor Brewer before she signed this bill that it was unconstitutional, that it would be struck down. Of course, she took a bring-it-on attitude for political reasons, I'm certain, related to her seeking election in her own right as governor of Arizona. But what's remarkable is that they knew the constitutional flaws, and they crafted the bill, they passed the bill, and she signed the bill into law, expecting and knowing that there would be lawsuits filed immediately. And indeed, there are at least 4 lawsuits already filed. There will probably be others. The lawsuits that exist, in particular the one that was filed by MALDEF, the ACLU, and the National Immigration Law Center, has been joined by a number of friends of the court. We expect there to be interventions, and those come not only from inside of Arizona, but from throughout the country. I think that there is a strong expectation and hope, a reasonable hope, in my view. I reasonably suspect that the court will do the right thing, carefully review the law, and preliminarily join SB 1070, and ultimately strike it down in its entirety. But among the constitutional flaws beyond preemption, there's a provision in SB 1070 that seeks to restrict the First Amendment rights of day laborers. But unlike other examples of this that we've seen, it doesn't seek to prevent the free speech rights of all day laborers, but only those who are undocumented, which is an unprecedented attempt to limit the First Amendment rights of a certain group of people based on their status. Again, in severe tension with constitutional values reflected in the First Amendment. There are also certainly tensions with the Fourth Amendment, certainly tensions with equal protection, because I agree with Jack, it's not just an invitation to racial profiling, it is a mandate of racial profiling. That mandate is supported by the provision that's been described that permits Arizonans to sue police agencies that they don't think are being aggressive enough in enforcing the law. So if the invitation weren't enough, if the broad sweeping application of the law to every stop, detention, or arrest were not enough, there is the added incentive of avoiding a lawsuit that would have priority in the Arizona court system filed against any agency that's not being sufficiently aggressive in enforcing SB 1070. So there's lots of major constitutional problems with SB 1070. Again, it is my hope and expectation that the judge that hears this in July will carefully apply the standard for preliminary injunction and reach the right conclusion. I believe that will occur. But of course, we all know in this room that occasionally courts get it wrong, occasionally courts don't apply the law correctly. And this should be a matter of concern to all of us in the room. It should be a matter of concern to all of us in the room that there are copycat proposals that are in serious discussion in at least 22 states after SB 1070 was enacted and triggered the nationwide reaction, much of it very hopefully in the nature of condemnation, but some of it seeking to replicate what SB 1070 does in other states and other localities. That ought to be a concern to us as well. But within the state of Arizona, I think we should be concerned that SB 1070 is not where they stopped. So when you think about the strategy of attrition that Jack has described, that this is designed to provide an incentive for people to remove themselves voluntarily from Arizona, think about who they're trying to remove when a week or two after Governor Brewer signed SB 1070, she signed a law that by design was intended to wipe out ethnic studies courses in Arizona schools, and specifically to eliminate a Chicano studies course in the Tucson school district. So exactly who is it that they're trying to remove by attrition? I think you get some sense of that by that effort. And of course, Senator Russell Pierce, who is the major sponsor of SB 1070, has now publicly indicated his intention to go further and to pursue next year an attempt to undermine the clear 14th Amendment birthright citizenship provision by making it more difficult to obtain a birth certificate in Arizona if your parents are undocumented, making it nearly impossible to do so, or even taking the extraordinary step of attempting to legislate that there is no birthright citizenship in the state of Arizona. So what is astounding to me is how openly Governor Brewer and those who support her have directly confronted the Constitution and directly contradicted constitutional values. We have to add to that in addition to the copycat proposals, we have copycat gubernatorial candidates, including in a state that should know better, because we went through the 187 experience, we now have a gubernatorial candidate who has, in response to one of her primary competitors, taken on a very anti-immigrant rhetoric and actually sought and secured and advertised extraordinarily the endorsement of Governor Pete Wilson, who championed Proposition 187. In New Mexico, we have a gubernatorial candidate who is running on an anti-immigrant platform. I think that we have to see this sitting governor and these potential governors standing in the way of application of our constitutional values as the new nullification. They are following the footsteps of those who half a century ago in the South, literally and figuratively, stood to bar progress. What is extraordinary, though, is that while those governors were seeking to stop a progression forward, a change in the law that was much needed and truer to the values of this country in Brown versus Board of Education, what these new nullifiers are doing is attempting to take us backward. They are challenging constitutional principles that have been in our Constitution for 220 years in many cases. They are not reacting to a change in the law that would take us forward. They are seeking to take this entire country backward. And it's incumbent on us as lawyers, it's incumbent on us as leaders to ensure that we confront this new nullification with all of the strength and unity that it took to defeat the nullifiers from half a century ago, and make clear in Arizona and throughout the country to these candidates, to these copycats, that we will stand up for our constitutional values, we will preserve those constitutional values in court and out of court to ensure that we go back to a path that's consistent with the traditions and values and future progression of our nation.
I was going to try to moderate and ask the panelists for questions, but I'm overwhelmed with questions from the audience. So what I'm going to do is ask them if there are any questions they want to ask to one another before I go on to the inquiries from the audience. No? Well, then let me start. And the first question goes to Professor Chin. And I'm reading. I've heard SB 1070 authorizes police to arrest any person for any removable crime without probable cause and without a warrant. If so, this seems to be a flagrant violation of the Fourth Amendment. Can you please address this issue?
The SB 1070 adds to the statute that governs warrantless arrests in Arizona. It adds the authority to make an arrest with probable cause but without a warrant for any public offense that renders the person removable. And it's challenged in some of the lawsuits. And I myself am not particularly anxious about it because it seems to me that it's completely constitutional to say you can arrest someone for any public offense. And so if you can do the greater, then the fact that they're also thinking about what makes someone removable or not doesn't really seem to invalidate this general arrest authority.
Now, the next question is, and I'll start the answer and then turn it over, but should the progressive community agree on a common set of gold standards for comprehensive immigration reform, and if so, what should they be? You know, and as someone who has worked in the area of immigration for 40 years, there has been a consensus on what needs to be done as far as reforming our immigration law. The issue in this country, and this is just my opinion, is that we're rather schizophrenic and play favorites. Number one, schizophrenic in the sense that we say we're a country of immigrants and we take pride in our immigrant roots, but it's particular immigrant groups. And that we fail to recognize that immigration is a push-pull issue. This country, when it needs the workers, winks an eye, and when it doesn't, returns to regressive laws. There are 12 million undocumented individuals in this country. I live in the state of California, and I will tell you that in the county of Los Angeles, there is 1 million undocumented individuals. 36% are Latino. The others come from every part of the world. And so the question is this really against undocumented, or is it against the Latino community? And what does that bode for us? There have been bills in the legislature and Congress that have sought to put forth a set of comprehensive reforms to address the issue. What immigration reform cannot do, and I can tell you this, is it cannot guarantee that it will stop the flow of immigrants, legal and undocumented, to this country. And the question that one should ask is it in the interest of this country to close the door on the past immigrants and future immigrants that have made this country great? Our Congresswoman talked about an immigration reform. Let me give you the three components, and I'll turn it over to Tom and to Jack. One is the issue of punishing employers for hiring undocumented individuals, a path to legalization for the 12 million immigrants in this country, an ag program, because our agricultural community cannot do with poor immigrant, whether it's H-2. And I will tell you that one of the most powerful lobbying forces in Congress is to make sure that you include an agricultural provision that allows you to bring more immigrants to this country. So those are the basic tentacles of what immigration reform should do. I also will close by telling you that immigration is an issue that doesn't sort of bring the general, sort of adversaries or the general allies together. It is it is an issue of strange bedfellows. You know, where the business community, whether it be high-tech, Silicon Valley, the agribusiness, contractors, construction, want these workers. And so you have the business community. Unions have come around, and now the majority of the growth in unionization is immigrants, and they're coming around to support immigration reform. And you have Democrats and Republicans, you know, who are opposed to any reform. So trying to find a consensus among the progressive community needs to start here with ACS. And with that, Tom, I turn it over to you.
Just one point. It's not the progressive community who will be the right wing that is making all of these laws in Arizona, because they are speaking out, they are getting people supporting them, and the good people, which I consider the progressive people, are not speaking out. They're saying this won't happen. Our Chamber of Commerces are in shock right now. Arizona's being boycotted. They did not speak out when the bill was going through because they thought that Jan Brewer would not sign it. So if not the progressive community, who?
First, the issue of comprehensive immigration reform has been on our national agenda for over a decade. And so the first and foremost thing that needs to happen is something. We need to ensure that as soon as possible we make progressive steps toward reforming our system. The community has waited too long, and we need to start to do that, or we are going to lose control of this issue. There is a danger that we've already lost control of this issue. I think that we've got to work together to ensure that some progressive movement is going toward addressing the major pillars of immigration reform. Now, in my view, that means starting with finding a pathway to legalization for the millions of people who have toiled and contributed to our society, to our economy, to our polity for so many years and have done so without legal protection. It also means that ultimately we have to reform our future flow, reform our immigration system. It also means that we have to, in my mind, ensure that we have a clear preemption principle. Constitution is clear enough for me. It's clear enough, I think, for most courts in the country. It's apparently not clear enough for Arizona or Hazleton, Pennsylvania, or Farmers Branch, Texas. You know the list of places that have done this. We waste tremendous resources on both sides challenging and defending these laws that are doomed to failure. And Congress needs to make clear that the Constitution means what it has been interpreted to mean. You, states, and localities cannot do this. I think it's critically important from the perspective of the progressive legal community that we work to inform the population about the need to introduce constitutional values. I talked earlier about defending constitutional principles and values in the face of these laws that directly confront them. But when it comes to our national immigration policy, we've never had constitutional values in our immigration policy. Because of the plenary power doctrine, we allow the Congress to do things in the area of immigration that we would never permit constitutionally in any other arena. But the American public doesn't know that, doesn't understand that this is an area of law where our constitutional values and principles have never been incorporated. The American public does not understand that today in 2010, despite the tremendous accomplishment that the 1965 Immigration Act was, to today in 2010, we still have an immigration system where two immigrants, potential immigrants, in the same family category, their wait to get a visa to legally immigrate here can vary between 2 years and 20 years, and the only thing that determines which line you're in is the country that you come from. Now, in any other arena, that would be racial discrimination, national origin discrimination that would not be tolerated. We tolerated immigration and still do, because we congratulate ourselves that in 1965 we changed the facially discriminatory national origins quota system to a better system. Well, it's a better system, but it's still a flawed system that doesn't fully incorporate our constitutional values. We don't incorporate values of due process, equal protection in our immigration court system, in our immigration adjudication system. Why? Because it has to do with immigration. We need to inform the public about the system that we have so that people will understand why we need to comprehensively reform it. And I'll end by saying this. Why we need to do this? Because I think there are two areas of the law that are incredibly complicated, with code books that are thick, that very few people understand them. But despite the fact in these two areas of the law, everybody has an opinion. Those two areas are immigration and tax. Those are the only two areas of the law. Tremendously complicated. The people who are experts on it could probably fill a room half this size at best, and yet everybody has an opinion. And those opinions too often are based on the disinformation that people get from Lou Dobbs, Glenn Beck, and others.
Question, and this is for Jack. Local authorities deliver suspects to federal authorities all the time. Why is this a problem in this instance?
Well, as I said, the existing system, the existing arrangements, at least in practice in Arizona, allow local police to make arrests for federal immigration crimes, and then they turn them over to the federal authorities for wherever the federal authorities want to do. But the federal authorities have made clear that they don't want people just grabbed because they're undocumented. If they've been charged with a serious crime, if they've been convicted of a serious crime, et cetera, that's one thing. But doing that, grabbing people who are undocumented and dropping them off at the Border Patrol office is a tactic that doesn't work because the Border Patrol doesn't want those people. And they don't want those people because they're engaged in organized crime investigations, they're engaged in trafficking of guns and money and drugs and trafficked people who are being forced to work in various ways. So it's not that the Border Patrol and ICE aren't already busy with a lot of important criminal investigations. They are. It's just that they really don't want to stop doing the trafficking investigations or the gun investigations and start spending their time deporting strawberry pickers. And so if anyone is going to prosecute undocumented strawberry pickers, it has to be the state of Arizona, and that's why they put these laws on the books.
Okay, this question goes to whoever wants to answer it. Although there has been a large public response to SB 1070, there has been little response to the Obama-backed Secure Communities, which may also encourage racial profiling and pretextual stops. Why is this?
We're so busy fighting 1070 and 287G, and the Secure Communities is a major concern. I think you will hear a lot, but we haven't yet defeated 1070. So as far as Arizona, we want both 287G and the Secure Communities gone.
I think it's not getting the attention because it's not talked about enough. It's almost a stealth initiative. I think it's important to get out in the public how dangerous Secure Communities is. It is very dangerous. It is a response to the problems that arose under 287G, but it will worsen those problems. I think it's very important to note that progressive steps toward comprehensive immigration reform don't only have to be legislative. Congress does have to act, but there are things that the administration could do administratively in the way that it handles things in immigration court, in the way that it prioritizes what it does from the federal enforcement side, in the way that it rolls out programs that are designed to address concerns in the community like Secure Communities or 287G. There ought to be immediately a moratorium on Secure Communities and 287G until we can demonstrate that we have in place the kind of federal protections for civil rights that we would demand in any other context. And that, ironically, the Department of Justice is responsible for imposing, hopefully, and strongly and progressively on a number of rogue police departments across the country. But they don't take that same lens and put it on their own federal enforcement to ensure that there's that kinds of civil rights systemic protections in place. And that's what we need to start demanding.
Okay, another question to Jack and Tom. How does SB 1070 ensure that public officials who might otherwise have full or limited immunity can be sued? Is it a simple blanket waiver of immunity? Is there a legal strategy around such a waiver to allow officials to refuse to enforce the law?
I think the agency is responsible for the judgment, and that the dollar amount of the judgment is capped at $5,000 a day. And so for a police department like Phoenix, you know, even 100 days is a relatively small amount in the budget of the Phoenix Police Department, which is a very large agency. So I don't think that there's a major question of personal liability.
Okay.
Am I wrong about that?
I think that the practical danger in that provision is the major concern. Nobody's going to parse the law carefully. It's going to cause police officers and agencies to exercise a great deal of caution, and they're going to over-enforce this law to ensure that they don't get sued. Now, to be honest, if they were to get good legal advice, if you want to make sure as a police agency, were SB 1070 to be implemented, and I don't believe that it will be, but were it to be implemented, if you want to be sure that you are going to avoid all potential liability, you have on the one hand this provision in SB 1070 if you're not aggressively enforcing enough. On the other hand, you have the danger that patterns of racial profiling could lead to legal challenges of their own. So what is the smart and prudent thing to do? The smart and prudent thing to do is to adopt a practice of asking for papers from everyone. So if it ever was implemented, I want to wait and see the first retired Scottsdale resident who has lost his or her papers, maybe that hasn't seen a birth certificate in decades, and gets asked for them. Now, I don't want that to happen because I don't want this law to be implemented, and I hope it and believe it won't be implemented. But truthfully, if they got good legal advice, any police agency to avoid as much liability on either side to navigate this narrow course, you would adopt a policy of asking for papers from everyone.
Okay, now I know we've had a little bit of the discussion on 287G, but this is the question. How should an immigration reform bill deal with the 287G program? It seems like the local governments which are participating would fight the repeal of the 287G provision.
I think that the experience in localities with 287G has been decidedly mixed. I think that there are political pressures to participate, absolutely, but I think in actual practice it's not resulted in the kind of law enforcement progress that anybody at the local law enforcement level would really be interested in. So I think that there may be some of that pressure, but it will be politically motivated. How do you deal with it in comprehensive immigration reform? I mentioned it previously. I think you've got to ensure that there are systems in place, and we know how to create these systems. There are systems in place to ensure that there are adequate civil rights protections before we implement any program like Secure Communities or 287G that involves law enforcement officers in immigration enforcement.
Just let me add to that. The abuses of 287G have to be addressed, and they have not been. They pulled the street 287G from Sheriff Arpaio in Maricopa County, but he still has the jail, and they've both been abused. So until the abuses are addressed, you cannot have a good 287G program anyplace in this country.
And I know we're running out of time. I can just tell you that I have over a dozen questions that will not be addressed. But I think it demonstrates the level of interest. And I would close one by thanking our panelists, but also saying to those here at ACS that this law is currently perceived to be against Latinos and Mexican immigrants. And the question for us is, it's Latinos, immigrants, Asians, and other immigrant-looking people today. Who will it be tomorrow? And where will we, as the progressive community, be in this debate? Thank you very much.